So there's good news and there's bad news, okay?
I like the good news first.
Okay, the good news is you're going to inherit $1 million.
Love that.
Okay. The bad news is that you have to wait until grandma's house settles and we can't find a will.
Okay.
That's the bad news. My name is Andy Norton. I am a realtor with Samson Properties in the Tysons Corner office, and my guest this morning is Lisa Mitchell, partner and principal in Ekko Title in the Centerville office.
Correct. Good morning, everyone.
Yeah, and you have been doing real estate closings and title for decades?
Almost 26 years.
26 years.
Yeah, so my daughter was 4 months old when I started.
Oh.
And she's going to be 26 in September.
Okay.
So that's how I manage that's how I can tell you really quickly how long I've been in real estate.
Okay, so I'm going to go off track because I had planned to ask you something different. She's 26.
She will be 26.
She will be 26.
Yep.
Does she have a will?
Not yet.
Not yet.
Not yet, but we do have a power of attorney for her.
Oh, okay. Outstanding. However, as we'll get to later in the show, the power of attorney, God forbid if she dies, that power of attorney ends.
Correct.
And she would then be intestate.
Correct.
Okay. However, let's sort of take this back to the beginning, that there are, big picture, you do real estate closings.
That is correct.
And of the universe of closings, some of the people are very much alive.
Yes, let's do it. Yes, for the most part.
Yeah,
yes.
for the most part.
Yes.
But as the population ages, and also having gone through COVID, in the last few years, have you noticed more estate sales, or is it pretty much constant in your experience?
This year especially, there's a lot more estate sales, and that's due to the current market that we're in. So not to go too off track, but because a lot of us are sitting on low interest rates right now.
Yes.
Unless you have to move, you do not. So the people that are selling properties are the people that are inheriting property through a death of a loved one.
Correct.
So we're doing actually a lot more of them.
Okay. Forgive me in the audience, I'm going to take you off track a little bit. If somebody had a trust rather than a will,
yes,
okay, and there is a mortgage on the house, isn't the trustee able to keep paying on that low interest rate mortgage because the property isn't being sold? It's the house would be in the trust.
So the trust would be the one that owns the property, and as long as, even in a normal real estate transaction, if you have a deceased person, all the bank cares about is that the debt is being paid.
Okay.
So they don't care who's making that payment. So yes, the trust would own it, and then the trust dictates who could sign on the behalf of that trust.
Got it.
So for real property purposes.
Okay, now we're going to get back on track. To start with, and we were speaking off camera before we started about this a moment ago.
Yes.
You do see people who don't have a will, who are intestate. And even though they don't have a will, if they end up at your office, there's a real estate contract to sell that house.
Correct.
But there's no will, so what's going on there?
So a lot of us know about probate. Okay, probate, people are scared of it. If you die without a will and testate, there's going to be a family member that's going to go to the probate office, and they're going to qualify as what's called an administrator of the estate.
Correct.
Okay, they're the people that are in charge of selling or taking care of all the information. They're taking care of everything that has to do with the estate. But being an administrator does not give you the powers to sell real estate.
Oh.
So when you qualify as an administrator of an estate, you're also going to file what's called a list of heirs.
Yes.
Okay? And then on the title side, for real property situations, we're going to ask for all of those people that are listed as list of heirs to sign the documents.
Okay.
Okay, so they would be signing your listing agreement, they would be signing the contract, they would be signing, we run judgment searches on all of them.
Right.
Okay. So we just, they're all the sellers. So if there's one, then we deal with the one, and then not to go dive too deep into it, but if you're only a single person, you're the sole heir, we're going to ask you to quantify that with people that are not related to you. You're going to ask them to do a statement that says that, yes, to the best of their knowledge, you are the only one that they know of related to this person that died.
Okay.
Okay.
Let's move on to people who have a will.
Yes.
Because one of the things that we were chatting about also is that you see wills that aren't quite perfect, that have flaws in them.
Yes.
Okay. So that a person could think that they have their quote-unquote affairs in order.
Correct.
And that their final wishes have been made known.
Yes.
And that their ducks are in a row.
Yes.
And then, if they were looking down either from above or looking up from below, either way, it gets to your office and there's a problem.
So we just had one recently. So again, they go through the probate office. They qualify as the executor, because if they have a will, there is an executor. Usually the executor is listed in the will. Mm-hmm. So who can act on the behalf, and there's always the powers within the will. There's always the powers to sell and who gets what.
Okay.
We just had a situation where executor qualifies just for the sake of the estate. You have 4 siblings, including him, but when you read the will specifically stated upon the sale of real estate that my grandchildren,
right,
each get X amount of dollars with the sale of real estate.
Okay.
So it wasn't clear. So when we read it, we said, okay, well, not only does the 4 siblings list of heirs, okay, they have to sign, we also want the grandchildren to sign. So the executor did not like that. So of course what we do is, if we have a situation where we know what we want to do, but then we go up to our title underwriter, they're going to help us try to figure out a way to get it done.
Right.
The executor, and I don't know what the reasons were why he did not want to qualify for the sake of the property, but he did not want the grandchildren to have to sign, to join into the deed. So we were able to get special consideration. We had to put some recitals in the deed, which is why I work with great attorneys, okay?
Yes.
To take care of the deed, because what we do is we want to make sure the title is intact. So if that will is part of the chain of title, people are going to read it and say, well, what happened to did these people get paid out? That's
Correct.
what the will specifically says.
That's right.
Right?
Yes.
Okay. So then if anyone's reading the chain of title, there's no way for them to see without putting it in the deed as a recital, or having the grandchildren also join into the deed that the transfer of the property they were okay with it.
Right.
We had to take care of that to make sure that there was no gap in the chain. Okay.
Yes.
Also, where title insurance is concerned,
I was about to bring that up.
the buyers, the buyers are protected against any unforeseen heirs or anything that they don't know. So if you have a grandchild that says, I never got paid out, and there was no evidence that we took care of that,
yes,
then they would make a title claim.
Correct.
So what ends up happening is, for this transaction, we just closed it actually, all the grandchildren were paid out on the settlement statement. Okay?
Yes.
And so we were able to track that monetarily, as well as our attorney put the recitals in the deed, basically being very specific about what was happening in the will, and then the four siblings, the original heirs of the deceased, were the ones that signed the deed.
Okay, so in that case, you're happy, the title insurance company is happy,
We're
the
so
heirs
happy.
and grandchildren are happy.
Correct.
But the executor was not, and that's tough.
The executor was at the end, but at the beginning,
Oh.
and he knew a little bit about what was going. I mean, he was well versed in the real estate process. He just any answer that we were giving him was not acceptable, because he thought it was just him and his brother and sister that needed to sign. He didn't understand why the grandchildren had to sign it, no matter how much we pointed to the will and said, well, let's read this together. We need to make sure that the way it was written is, upon the sale of my real estate, these grandchildren will be paid out. And it was a specific amount of money. So we're just trying to close loops, because we don't want issues for the new purchaser. When you enter a chain of title, we don't want any issues behind the title going in. So we do our best to to sew it up beforehand.
If I'm correct, Ekko Title sells what I would call regular title insurance and also an enhanced policy. Is that correct?
We do, and we underwrite through two title companies. So it's Commonwealth, Fidelity, and then WFG.
If you're a buyer of a property that's in an estate,
Yes.
is there particularly an advantage in that specific circumstance? It's an estate for the buyer to buy enhanced extended coverage title insurance, or not particularly one way or another?
Okay, I'm a very risk adverse, so
Yes.
we're always gonna give you, and we're always gonna quote the enhanced policy. Okay, it covers appreciation, it covers, unforeseen errors. The standard policy does that as well. But it just covers other things that people don't know. Like we think we do everything right. We think that we've gone through the chain of title. We know that everything's intact, but there's things that we don't know that the enhanced policy, without getting too deep into it, would cover more than the standard policy.
And really, getting a bit off track, you can tell that we are both risk averse.
Yes.
Because we are doing this video in a studio with a videographer and not with an iPhone out on the street. So we are both risk averse. Okay. Let's talk about trusts. Okay.
Okay.
My impression, tell me if I'm wrong on this, is that if somebody actually, well, if they have a trust, they've gone to an attorney.
Yes.
Okay, they're not going to do a trust downloaded off the internet or something like that.
Well, they could.
They could.
They shouldn't. But they shouldn't. They should. If you are interested in putting your property in a trust, and a lot of people are saying to avoid probate, to avoid, taxes, inheritance taxes, you want to speak to an estate attorney first.
It's my impression, am I wrong, that if somebody has gone to an attorney and paid the attorney fee and the attorney has set up a trust, that there will be fewer problems on a real estate contract when it gets to your desk than, let's say, on a will? I mean, is a trust are they generally done right?
That is the $1,000,000 question.
Okay.
So the trust, for title purposes, what we're looking for in the trust is obviously, what is the name of the trust? When was it entered, and so what day? So when you're doing your listing agreement, the full name of the trust is the seller. It's not.
Correct.
It's not just Mitchell Family Trust unless it is fully stated. The Mitchell Family Trust is usually the Mitchell Family Trust as stated, entered into the date of. So it's very long. What we're looking for is in title is we're looking to see who the trustees are and who can act. So a lot of times you're setting up family trusts. So my husband and I, if we have a trust, can they act independently for the sale of real estate, or do they need to act together?
Yes.
And that's what we're looking for. Because the trust in companies, it's a binder that's this big. So and people get very tense about their personal information.
Yes.
So when we talk about a trust, we say, okay, open up your binder, look at your table of contents. As it pertains to real estate, there's a small chapter, maybe a page or two, that's going to give us the information that we're looking for as it pertains to title. That is all we're looking for.
Okay.
Okay?
Because I've been doing real estate roughly as long as you've been doing closings and title, one of the things that I have seen all too often, at least half a dozen times in the last couple of years, are people who have trusts, but the real estate has not been put into the trust. So when I meet with them to list the property for sale, they will say, oh, I have a trust.
Okay.
And my presumption is that if they have a trust, that the real estate that they're selling is in the trust. But a bunch of times it ends up that the property is not in the trust for some reason. And in that case, even though they have a trust, the trust isn't the owner, and they're still selling it.
Correct.
Individually.
Correct. So usually people buy real estate individually. They set up a trust, and then they do a deed from themselves into the trust.
Right.
A lot of lenders do not like to lend in a trust. So
to lend into
a trust. So if you own the property in a trust and you refinance, a lot of times you being asked to take it out of the trust. So we have to deed it out of the trust for the sake of doing the refinance, and then we deed it back into the trust. There are situations where that has happened, and then they decide to keep the property out of the trust, or they just don't ever get it back around to putting it back into the trust.
Okay.
Okay.
Wouldn't there be additional recording charges to put it back into the trust?
Oh, yes.
Which may be another reason that
It's
people don't want to...
It's $36. It's 200, and if we would draft the deed, it's between $235, $250. We draft the deed. It's worth the money. Because the reason why you set up a trust is to make sure all your assets are all in one place and easy to, to find and, to speak about. And you hand your family a copy of your trust, and you say, this is all you need to know.
Correct.
The thing is that, everyone has the best intentions when they set this up. It's just questions you ask. So if you have a trust, put your property in the trust.
Yes.
If you take it out to refinance, then you want to put it back in the trust. Mm-hmm. It's worth the $200 and some dollars. It's under $300 for you to do the deed and record it.
You've no doubt heard the expression that the road to hell is paved with good intentions?
Yes.
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 Do you see sales, is it predominantly a revocable living trust, or do you find also irrevocable trusts, charitable remainder trusts, trusts for cares of minors, or do you mostly see a revocable living trust?
I mostly see irrevocable trusts.
Okay.
Irrevocable trust or revocable.
Okay.
I don't see the guardian trusts or anything. I don't see any of that usually. I haven't yet.
Okay.
Okay.
All right. As far as on the realtor side, mm-hmm. I mean, I will tell you that I do my best. There's an expression of financial planning, not so much in real estate, know your client.
Yes.
Know your client. And I and a lot of agents, we try to know our clients, but sometimes they are less than forthcoming.
Right.
Okay.
Yep.
Are there things that you would like to see, being on the title side, from the real estate community, from the other side, that you would like to see agents be more proactive or dig a little deeper? Or are there things that realtors could be doing and should be doing that from your point of view we may not be doing?
Well, I think whenever you go on a listing appointment, you're doing your CMAs, you're going to pull the tax record. Mm-hmm. Tax record will say, Mitchell, Lisa Mitchell, comma, trustee, and et al., because they don't have enough space to type it in. So you're going into your listing appointment knowing it's a trust. Okay? If it's an estate and they haven't gone through probate or haven't changed in the tax record yet, but you go in and the first thing they say is, my father just died. We have a probate, we have an appointment with the probate office. What you want to do is say, did he die with a will? You want a copy of the death certificate. I mean, all the things that, how much do you think he owes? Do you have a mortgage statement? All the things that you're asking about. Mm-hmm. Do you know, was he, other things? We've had one where we went into a short sale situation because the children couldn't find a mortgage statement. And they thought that the property was worth X, and then they could only sell it for Y.
Correct.
So, you want to get the whole financial picture and let them know that you're a trusted advisor. And the only reason why you're asking these questions is because if you get all the upfront information now, mm-hmm. the easier it's going to be for them. And you can advise them to their next steps, because some people just don't know.
And that's fair. A lot of people just don't know. They
just don't know. They don't do this every day. It's not something that you're not an attorney dealing with estates. You just don't know until you're dropped in your lap and you're the executor of your parents' estate. Mm-hmm. And now you're dealing with emotions, you're dealing with family, you're dealing with your siblings who you had a great relationship with, and now everybody's like going different directions and having side conversations. So the best thing you can do as a listing agent is pull a tax record, do your CMAs when you come in, ask them all the questions you normally would, but you need to get the documentation. If it's a trust, you need a copy of the trust as it pertains to real estate, because you need to know who can sign your listing agreement. Mm-hmm. We can, as a title company, it's very easy for us to pull the current deed if you need us to. Mm-hmm. If you don't think your client is forthright, being forthright with debt, we can certainly do a preemptive, what we call title bring down for the sellers before you go into closing. We can do a net sheet for you. So when you're going into your listing appointment, you have all your numbers, you have the deed, so you know how they took title, you know that they opened 2 mortgages. Maybe there's a lien or judgment that we have to deal with, but those are the things you want to ask for. Are you current on your HOA? You know, because that's what you need. Those are the things that you'll be dealing with. You don't want surprises.
At the point where people get to you and you meet them, and there's a death involved,
Yes.
are they still grieving, or is it pretty much just business? I mean, at the point where I meet them, sometimes the death is very recent and it's raw. But by the time you meet them, it could be half a year to a year or more later. I mean, do you have tears at the closing table, or is it pretty much business?
It depends on the timing, truth be told. It depends on the timing. If it's usually, 3 months, 6 months, 9 months, they've already gone through the emotion. They've kind of stuck that in the background. And they're just dealing with, like, it's a business. Okay, I've got to get this done, this done, this done. They've got all of their folders. They've got all of their checklists. They know what they've done. They know what they haven't done. They have certain questions. With estates, we try, and I know you do too, you try to be very cognizant of the fact that they just lost. So at the settlement table, the last thing I want to say is congratulations, you just sold your house.
Yeah.
But you want to say, and there's always tissues. So we always say, because sometimes it's like, lots of tears. But at the end of the day, we deal with the people individually. If they need to take a moment, we have them come in. I find when they come in to talk to us and they have specific questions, they bring everything that they have, and we just go through and get what we need. So, if they're overwhelmed, a lot of times they have a lot going on, they can come in and schedule an appointment with any of us. We'll sit down, say, bring all your paperwork, and we'll take and make copies of everything that we need and hand everything back to them.
Now, all of this is on the seller side, the
Correct.
estate side,
Yes.
the executor side, the administrator side, the heir side. Does the buyer have a clue of what is going on and what you're doing, or they're just showing up and buying a place?
The buyers don't really need to know. I mean, they know based on if it's the estate of, they know that they're dealing with an estate.
Okay.
And they know who they're dealing with as the person signing the contract. They know that, but they don't need to know any of that. I mean, we're very private. We give the information that we need. We keep the sellers separate. We keep the buyers' information separate.
So there's pretty much a firewall
It's a
between
firewall.
the two.
The buyers would never ask me a question about
Okay.
probate or anything like that where the sellers come in.
Okay.
Sometimes the buyer's agent will ask me a question, how's it going? Do we have all the paperwork? Are you good to go?
Yes.
And I'll say yes. Or maybe I'm talking to the seller today, we're still waiting on one thing. The check-in is always welcomed by the agent, but I never have a buyer come to me and say, what's going on? Usually.
Usually.
Yeah. Usually,
Okay.
I've not had that, but like the selling agents will check in and say, do you have everything you need? I know this is an estate. I'll say we're good, as long as we're good.
Okay. Often there is a 45 to 60-day period written into a contract of sale to go to closing. If it's an estate, are you generally okay with 45 to 60 days?
Well, we operate on the contract terms. So as long as they've done they've got to make their, first and foremost is your question to them is, have you probated the will? Have you gone to the probate court? If they say no, have you made an appointment with the probate court? Because they have to do that first, okay? We have to have that documentation because then we know who's signing, who can act. Is it an administrator? Do we need to get affidavits from third parties to say yes, he's the only child of this person that died? All of those things we need to know. So we get a contract. We ask for the documentation on the estate side. We pull the title work. If it's not in the chain of title, then we call you and say, when do they have their probate? Because the probate office will file the letter of a qualification,
Right.
list of heirs, real estate affidavit, the will, executor, the qualification as an executor. So all of that gets put into the chain of title. So before you list, that should be done.
I was just about to ask that. Certainly one of the questions that a listing agent should be asking right out of the gate if there's an estate.
Have you done probate?
That's right. Was there a will?
Because if they
probate?
can't sell the property
Yes.
without being qualified to sell the property. So as an administrator, obviously list of heirs, who is going to sign on the behalf of the property. As an executor, they have the powers to sell. Then we need to know that too.
Let's sort of conclude with another situation, which actually I ran into 2 weeks ago, but I'm running into it a lot, and that's powers of attorney.
Yes.
Okay. And one of the things that we spoke of off camera, why don't you tell the audience what happens with a power of attorney when the person dies?
So a lot of times with estate planning, your estate attorney will do your wills, your durable power of attorneys, your medical directives. So as people get up in age, they're usually one of their children act as the power of attorney with a durable power of attorney. Okay. As title company, we would prefer a specific power of attorney, which means this person has the right to specifically sell this house for me. But what we're finding is as people get up in age or they're terminally ill, they may not have the ability to do that.
Right.
So what we do is if you have a durable power of attorney, usually you only have one original. We do ask for them to bring it in.
Right.
Okay, so we can look at it. Again, we're only looking for, do they have the power to sell real estate? If they do, we send it up to our underwriter and get underwriting approval to use the durable power of attorney versus having them sign a specific power of attorney. We will ask for a specific unless someone cannot physically sign another one in their right capacity. So just know that we have to have the original. It has to be certified, and we have to upload it to the county records with an affidavit saying that you did act on the behalf, you are the power of attorney, called the power of attorney affidavit. So what we ask is, because it's probably your only one, come in, bring it in, we'll upload it to the county before closing, we'll get it recorded, and then we'll hand it back to you. Because a lot of people cannot part with that. So just know that. You might want two. You might, if I were you, I'd have one in my safe and one that you carry around with you to do everything you need to do.
And again, as the population ages, you have more and more people with dementia and other illness issues.
Yes.
Those families should affirmatively be getting powers of attorney before things get too far gone?
Yes.
Okay.
They should, or they might be in a situation where they have to be appointed a conservator or a guardian.
Which again involves going to court.
Yes.
Okay. All of which is to say, after half an hour, that your path to this $1 million inheritance may have some bumps in the road.
May have some roadblocks.
That's right. But that ultimately the money probably will end up in your account.
Correct.
Okay.
Correct.
Lisa Mitchell, Ekko Title, thank you very much for your insights this morning, and we hope that the audience is both better educated and, dare we say, entertained?
Entertained.
Entertained,
Andy,
definitely.
thank you for having me. Okay. And again, you have any questions at all, you just let us know. We're happy to draw you a roadmap to closing.
lmitchell@ekkotitle.com?
That is correct.
Okay. Thanks very much, guys.
Bye.
See you next time.